Thank you very much, and welcome to the Debating Union. Today we have a debate. We have our speakers for both the proposition and the opposition. A few rules. The various speakers know how long they've got to speak for, and I've got a very, very big bell that suggests if you speak longer than that, you will hear it quite loudly. So thank you for all taking your seats. I'd like to point out at this stage that where you've taken your seat, there's absolutely no relationship whatsoever to how you think on the motion, okay? So I don't want everybody suddenly rushing from one side to another. The way we're going to do this is we have our proposer, and then we have our opposer. We will then have our second proposer and our second opposer, and then we open it up to the floor. So show of hands of anybody that would like to ask a question or make a point with regard to this debate. And then we close by the proposer and the opposer having a final 5 minutes to sum up and convince you in that last moment of where you should place your votes. Now, as you'll see, this has been going since 1815. We have had many, obviously, very famous speakers here, but none more famous than we have here with us today. It's based, as you probably know, on the Houses of Parliament. There is actually voting doors, but I've been told by Stuart that we're not using them. Okay, so other than to go and get a drink, there's no disappearing through the eyes and the nose because there's no counting, and therefore we'll just lose you completely. The other issue is in a traditional Cambridge Union debate, there is the possibility of interrupting a speaker for a point of clarification, similar based on obviously the Houses of Parliament, but we have decided to not permit that today because we have plenty of time for speakers from the floor and really to get the argument conveyed as clearly and as succinctly as possible. We're not going to have interruptions. So I would ask you all just really to bear with us with regard to that and hold with your questions. Now, as you should be aware, the motion today is this House believes that the EU GDPR is important, in practice, a protectionist trade instrument. So it's about looking at data protection not as a human rights instrument solely, but also recognizing that data protection law, as we all know through our experience, has serious implications in terms of international trade. And so the proposer today is Dr. Ulrich Wuermeling. He's a visiting professor at Queen Mary, so he's a colleague and in fact was a student. No, so if Stuart's going to say I came to the first privacy laws and business, I get to say that Ulrich was my student in my first year at Queen Mary, which was 31 years ago. So we're all aging somewhat in this particular field. And he is supported. The seconder is Tatiana Kruse, who is of Counsel to Dentons, the law firm. Our opposer is Dr. Orla Lynskey, who is Associate Professor at the LSE Law School and Visiting Professor at the College of Law in Belgium. And the seconder against the motion is Alexander Dittel, a partner at Wedlake Bell. So I would like to thank both sides for agreeing to debate today. I would like to remind both sides that physical violence is not permissible. Although I do see something down here, I'm not sure what that's for. And without further ado, I will retire to a very large chair up here. I don't really want to do this, but I've got to do this. No, I'm taking the bell with me. I'm taking the bell with me. And with that, I will hand over to Ulrich to propose the motion. Ulrich, you have 10 minutes starting from
Thank you very much. Thank you, Mr. Chairman. Thank you, Tatiana, for helping me in a moment. And thank you for Orla and Alexander to oppose me. I hope we will get to a conclusion today. I will look forward to all your votes and also to your contributions, because after our speeches, each of you can stand up for 3 minutes and say why I'm right and why the motion has to be supported. If you have a different opinion, don't stand up. No, you can if you want. The House believes that the EU GDPR is in practice protectionist trade instrument. So let's have a look. In practice, have a look at your phones. Where are your phones from? We have US, Apple, Motorola, Google, South Korea, Samsung, China, lots of different players, and from the EU, Nokia, and you could doubt whether that's EU anymore because it was purchased by Microsoft. So your phones are not usually from the European Union. Where are your app stores from? Apple, Google, the Windows Store, Amazon App Store, also not from the European Union. What is on your mobile phones? TikTok, WhatsApp, Telegram, Instagram, Facebook, Zoom, Messenger, Microsoft Teams, Spotify, and so on. Also not European Union. And where's your taxi app from? More than 50% of the taxi app users in Europe are Uber, also not from the European Union. Where are your games from? If you go through the first 9 games, they're all not from the European Union. Number 10 is the first one from the European Union, even though I have difficulties to distinguish the games because they're all about shooting people dead. So we don't see actually that there is in practice much of a trade barrier when we look at our phones, because obviously all these players are here. But the tide is shifting in that respect. And one of the reasons for that is fines. The enforcement of data protection law has made huge steps in the past years. So we have 1.2 billion, 405 million, 390 million, 265 million against Meta in Ireland. We have 746 million against Amazon, 224 million against WhatsApp in Ireland, 90, 60, 50 million against Google in Ireland and in France. So we see there's a lot kind of going on. Then we have the potential risk of damages. And the potential risk of damages means, if you look at the Representative Actions Directive, which has to be implemented this year in the member states, that there's a lot more potential of large damages claims, not class actions like in the US, but something very similar to that. And there's the Court of Justice of the EU, who has judged on the question of damages and doesn't provide a big threshold to getting the damages, and also makes it very difficult to excuse yourself in a way that you would prove that you are not in fault. So, and then we have restrictions, for example, on data transfer, the Facebook case we all know about. So the consequences of breach are much bigger than they used to be, and that constitutes a risk. And now then the big question is, would you walk into Europe or a global launch of an app today in a situation where you are probably not fully compliant with the laws in the European Union and you're facing these risks? And because of that, it is absolutely clear to myself that privacy law is a trade barrier, because you will not enter the European market because of privacy law. Another question whether it's a legal trade barrier or not. What we're looking at is the question whether it's a trade barrier. The other thing you will lose then is the first mover advantage. The global launches of apps, for example, gave you a first mover advantage around the world. Now it's like in the cinema, where we used to get the Christmas films from the US and Germany, we got them in the summer because they first had to be translated. Yeah? And the same happens then with apps. They first have to be implemented in a way that it works here. So we see this shift. We also see a shift in the business-to-business data protection issues, because you have the Schrems decision, for example, where businesses say, well, we don't want to use non-European providers because we want to keep out of these problems. Yeah? And all of this makes it very difficult, especially for new and smaller businesses from other countries, to enter the European market. So from that perspective, when we now look at the WTO agreements, I believe we would have the data protection law constitutes a trade barrier. The General Agreement on Trade and Services, though, has a exception with respect to privacy law. So you can have barriers in order to protect privacy. And but they have to be necessary, they shouldn't be discriminatory, and there shouldn't be disguised restrictions. And now, let's have a look at what happens with the GDPR, with 4 examples. One is the German cartel office case that was today decided by the European Court of Justice. If you look at the requirements of the case, you will see that when you want to use the balance of interest clause, you have to make sure that you only use or you only process data which is really necessary for the purposes and nothing more than that. So that means technological requirements to how your services work. If you want to import into the European Union your new product, which is to some degree maybe experimental and therefore has some data that might not be strictly necessary, yeah? You will have to change that before you can actually do that. Then there is the Adequacy Club. These are the 14 countries in the world that have an adequacy decision by the European Union. However, there are many other countries that have data protection laws that don't have an adequacy decision. And it is discriminatory between countries if one country doesn't have an adequacy decision, but still has adequate data protection law, and the other country has one, because their opportunities to make trade are very different. That would be a discrimination, also not allowed under the exemption of the GATS agreement. And disguised restrictions, I'm not entirely sure, but when we discussed the GDPR in the parliament, some people said, we want to put chains on the big American players. Yeah? And maybe they were trying to do that, but I don't think it was really the intention. Then the processor trap is one other example of how the GDPR protects European, or how the GDPR actually does something else. It does not allow non-European companies to use services in the European Union. So let's have a cloud service provider in the European Union, and then they provide cloud services to controllers outside the European Union. The trap is that the European Commission seems to believe that then the GDPR becomes applicable for the data. So you give the data to the cloud service in the European Union, no problem, but you don't get them back, because then the data is protected under the GDPR. The processor is obliged under the third country transfer provisions to comply with them, but you can't. I don't believe that's necessarily right, but the Commission has put out standard contract clauses for that. And then there is the extraterritorial effect, which is a problem. We heard about Asia, for example. In Asia, we have data protection laws that are very much consent-based. If you have extraterritorial effect with data protection laws from different countries, and you're working cross-border, you automatically get in a situation where you have to comply with both. Yeah? And now you have the problem that you have to get consent under the Malaysian Data Protection Act, and you can't get consent under the GDPR because it wouldn't be seen as freely given. So how do you comply with that? That is also a trade barrier in my view. So what the motion is about is to make clear that international trade is important, that we need proportionality in the way it's applied, and therefore I invite you to support the motion and give me your vote. Thank you.
Thank you. I could call upon Orla to speak against the motion.
Mr. Chair, distinguished opponents, ladies and gentlemen, we've been asked to consider today the motion that this House believes that the EU GDPR is in practice a protectionist trade instrument. Not a trade barrier, a protectionist trade instrument. So my distinguished opponent would have us believe that this is simply a question of whether or not the GDPR constitutes a trade barrier. We might say that the GDPR has an impact on trade, like any law or regulatory instrument, but that's not what we're being asked to consider today. So let me go back to the motion that is put before us and go to some definitions of key terms. So we cannot debate or discuss this motion without thinking first, what does protectionism mean? So if we go to the Oxford English Dictionary, we see that protectionist is defined as something that is in favor of supporting a policy of protectionism. What is protectionism? This is the doctrine that domestic industries, here in our case EU industries, should be protected from foreign competition by the imposition of duties, quotas, etc. on foreign goods. Going closer to home, because we're in Cambridge, the Cambridge Dictionary says, this is the actions of a country or a region to help its country's trade or industry by taxing goods brought in from other countries. If you look beyond the dictionaries and you look to leading scholars and authorities on WTO and trade law, you see that they put protectionism in opposition to trade liberalism. And the defining features of trade liberalism are market access in a non-discriminatory way. So what myself and Alexander are going to put to you today is that the EU regime is not protectionist, because it doesn't meet the criteria for the definition of protectionism. It doesn't meet these criteria, which we identify as being kind of twofold. First, there is no intent here on the part of the EU to protect its own industries by disadvantaging the industries of other regions or countries. So the economic rationale of protectionism is lacking from the EU regime. That's the first point we'll make. The second point I'll make is that the impact here is not a discriminatory one. If the EU GDPR has a negative impact on trade, it has an equally negative impact, whether you're an Asian company or an American company or a company from elsewhere in Europe but outside of the EU. So we're lacking the critical condition of discrimination. So neither of these conditions are met here, and therefore we must oppose this motion. So first of all, turning to the economic rationale of protectionism. Why would we say, and Alexandra would put this more in its historical context later on today, but to begin with, we would say that there's no economic rationale for protectionism in the EU, because if you look at the origins of the GDPR, we see that its predecessor, the 1995 Data Protection Directive, had a firmer footing in the EU's internal market. It found its legal basis in what is now Article 114 of the TFEU, which says that the EU has the possibility to introduce legislation that removes barriers to trade or barriers to movement of things like, in this situation, data across the EU. Fast forward to 2009, the EU treaties were changed. We see that a specific legal basis, which is not grounded in an economic rationale, which is not the internal market legal basis, is introduced for data protection in Europe. And that is Article 16 of the TFEU, which states that in Europe, data protection is viewed as a fundamental right, and as a result, paragraph 2, the European Council and Parliament, so the EU legislature, should enact rules, which we have, the GDPR, to protect this fundamental right. So the GDPR's rationale is not economic, it is a human rights instrument, albeit a human rights instrument that, of course, like any other human rights instrument, will have impact on speech, or will have impact, sorry, on trade. You could say labor regulations, which give workers minimum rights, have an impact on the labor market, possibly the free movement of workers and other things, but at their outset, they are human rights instruments. So here we have consistently the idea that the GDPR is an instrument, the objective of which is to promote the protection of fundamental rights in Europe. And as a result, it lacks this economic rationale of protectionism that is required for something to be categorized as protectionist. And we could think of analogies. For example, in the US, the First Amendment protects free speech. Obviously, because free speech is protected, this means that we can have more speech on digital platforms. This might benefit the US big tech platforms that monetize speech. But we would never say that the rationale for the First Amendment was to promote the business models of Facebook or Meta or Google or Twitter or any other US tech platforms. That's simply a byproduct. And similarly in the EU, any impact on EU tech companies or non-EU tech companies will be a byproduct of the application of the GDPR. The second thing that we need to think about is whether or not, as required by protectionism, we have a discriminatory measure. So whether the GDPR discriminates between EU companies and non-EU companies. And here again, I think we find the evidence for this is lacking. The motion suggests that we're holding non-EU entities to a higher standard than we're holding EU data controllers. Whereas, if we take something like the adequacy standard, that is explicitly not the case. It's explicitly a non-discriminatory standard. The standard is not more than or higher than the level of protection that EU data controllers must offer. It is a standard of essential equivalence. The protection offered by a non-EU controller has to be no more, but also no less than that offered by a data controller within the EU. And of course, the justification for this is that we don't want to circumvent the EU's legislative protections. And that kind of anti-circumvention logic is entirely compatible with WTO rules, provided it's not applied in a discriminatory way vis-a-vis non-EU providers. So just as we wouldn't say that the EU's financial services regime, which also has an adequacy threshold, is discriminatory and protectionist, equally I don't think we can say the data protection regime is discriminatory or protectionist. Now, my colleague has raised the point that this EU regime has an extraterritorial impact or effect. This is, of course, the case. If you want to import data into the EU or offer your services, let's say, to users in the EU, you must comply with the rules of the EU. But we see this extraterritorial effect in other areas of law. For instance, we've mentioned competition law. If you are a cartel in Canada and you are importing products to the European Union and the price of those products is higher as a result of the cartel, then it is commonplace in EU competition law, but also US competition law, for that kind of extraterritorial impact. So the key criteria here is always, is this discriminatory in its application? Now, we might say, well, adequacy is discriminatory in its application. However, the counterpoint to that, of course, is that even though we only have 14 countries that are recognized as adequate, they are the countries that have applied for adequacy. So the EU doesn't put any impediments in place to countries applying for adequacy, and the way in which it selects who gets to benefit from the overall assessment of adequacy is applied in a non-discriminatory way. Of course, that doesn't mean that all countries will be deemed adequate, but that's because it's a substantive standard. So just to wrap up on this, the idea that privacy laws are not by nature discriminatory is in fact recognized already in WTO law. You look at the General Agreement of Trade and Services, you see that there's an exception that applies to privacy frameworks, provided that they're applied in an equal way, recognizing that states can introduce legislation like privacy legislation, and that will not constitute an unlawful impediment to trade. So here again, it might impact on trade, but not in a discriminatory way with an economic rationale, and therefore we can't say it's protectionist. So, yeah.
Oh, can I please ask Tatiana Kruse to hobble up to the... Thank you very much.
Apologies for the hobble. Oh, I'll just take it, but I'll take it. Okay, thank you. Right, I'll put it down. I'll put it down here for the moment. I'll put it down here for the moment. Yeah.
Okay.
Okay. Good afternoon, fellow privacy professionals. My honourable friend Ulrich, I don't know if that's how you refer to people in a debate, has explained how data protection laws, in effect, in practice, result in trade barriers. What I'd like to do is just to give some practical examples of how this has worked and how there are some strange results of the GDPR which do not result in protecting privacy, and in some cases actually rather go against protecting privacy. And I'm going to use a visual aid, which is this. I was told that I'm not allowed to have slides, because that's against the debating rules, but that the US Senate allows cardboard. And as an American, I felt that I could use a bit of cardboard. So here, I'm not going to read it out, because you can see what is being said here about privacy. This cartoon was procured, invented, whatever, by my colleague at Dentons, Kwan Hon. So thank you, Kwan. She sent this to me. Incidentally, she's written a book called Localization Laws and Policy, published in 2017. That wasn't an ad, that was a service message. Okay, now, being a bit more serious. I do think that some of the focus on privacy laws per se has been lost. You know, we had the famous article by Warren and Brandeis, we had the Universal Declaration of Human Rights, we have the European Convention and so forth, when privacy was enshrined as a human right. But now what we increasingly see is personal data as an asset, personal data as a piece of property. It's the property of the consumer, or it's the property of a data user using that data. And European countries and the UK, they want to be top nation. They want to be foremost. We especially see this in some of the recent pronouncements that governments have made about how they want to be the world leaders in AI. But what's getting in the way of Europeans becoming top nations, and I'm not partial about this, I've been living in this country longer than most of you have been alive, is big tech in the US. So big tech in the US, they have a comparative advantage. It's noteworthy that the Schrems litigation, from which a lot of these restrictions, where they've been tested, concerned a worry about the overreaching powers of the US security agencies, which it was feared could get hold of European residents' data, and European residents' data was being stored by US big tech, because US big tech is very good at processing personal data. And so that's where it gets sent. By the way, I'm not against protecting domestic industries. I'm not against protection of infant industries. I think it's a justification for a trade barrier. But I think we ought to be looking at the pros and cons of what we're doing when we're talking about protecting personal data. Going back to Schrems, so the biggest market, and going back to US big tech, the biggest market shares are AWS, globally, AWS, Microsoft Azure, and Google. And those companies, because of the European worries about data exports to the US, they put their, sorry? Oh, they put their trade barriers in. Okay. Very quickly, your personal data is better protected, stored by US companies in the US than it is when it's stored by US companies over here, because Executive Order 12333 puts restrictions when it comes to processing the data in Europe, but puts prohibitions on processing the data in the US. So at least this is what my US colleagues are telling me. Okay, a couple of illusory examples. If you send your data straight to a US retailer or a foreign retailer, a third country retailer under Article 3.2, you're apparently regulated. You don't have to have a data solution in place. But how is this going to be enforced? Your data aren't better protected. Okay. All right.
Alex.
Well, thanks so much for excellent submissions so far. But the question is, if the GDPR is a protectionist instrument, then why is US tech leading the world and everyone is using US tech? It miserably failed to protect any European industries which simply failed to get a priority position in the marketplace. And if you look at the history, it's kind of stems from historical developments after the World Wars. Obviously, the OECD guidelines from the 1980s, they were intended to actually prevent transfers, prevent barriers on transfers, and this is emphasized a lot in the document. But I also envisaged that privacy laws around the world would develop at a similar pace and would be based on human rights as the priority. Unfortunately, that hasn't happened, and the OECD guidelines do allow for restricting transfers, and this is simply how domestic law in Europe has developed. It's matured. It's an example to the world, which is being copied by many nations. And it is there to protect the individual. Trade is important, of course, it's driving force. But let's not forget human rights, particularly with the unknown future that's coming, in terms of AI and further technological developments. And there is no law to stop EU citizens, for example, to use US tools and services, and indeed they do. They are free to use the websites. No one is stopping them from that. But basically what the law says, if you are using a domestic service provider and they then rely on US service providers, then you expect a certain level of commitment to compliance from that domestic provider. And I guess that's where a lot of the tension lies, but there's no prohibition on the use of any foreign services. It might be argued that obviously as a result of all kinds of case law and the CJEU's sometimes unfortunate interpretation, which again is very much geared towards the benefit of the individual. It's not really taking trade into account. If it did, it would make very different conclusions, but it didn't. So we are in the kind of situation where, in effect, it looks like barriers, but in fact it's stemming from a totally different foundation, which has little to do with trade. And actually, trade is something that should be emphasized, and perhaps there's another need for the European Commission to review some of the legislation. But yes, basically, just because a hammer can be used to harm people, it doesn't mean it's a weapon that needs to be banned. There's a lot of good use to it, and equally the GDPR has its purpose. And just because some of the situations that have evolved kind of play into the hands of those who claim, to protect local industries, it doesn't mean that that's the fundamental purpose of it, and it's potentially an abuse of the GDPR. So, what else can I say? I think I rest my case. Thank you.
Okay, thank you very much indeed to all the speakers. I'd now like to open the debate to the floor. So you can either ask a question of one of the speakers, whether proposer or opposer, or just make a statement that you think in favour or against the motion. But you have a limit of a maximum of 2 minutes to make that point, he says, just trying to set his timer again. So I will start with you, sir. Could you please give your name first and your address?
So I would say that EU consumers are using USA tech because they're quite happy they're quite happy with sending their data to the USA, for example, and that data to be stored and processed in the USA. But EU regulators put almost impossible barriers on EU companies sending data to the USA because to send data to the USA seems to be the position with data protection authorities that the data has to be transferred encrypted, which is fine, but when it's at rest in the USA, it also has to be encrypted as well. Otherwise, they won't see that as being suitable safeguards. So effectively, it stops EU companies from being able to use world-class leading non-EU companies for cheaper prices for their customers. So I'm in favour of the motion that it's protectionist.
Thank you very much. Speaker David.
I wasn't intending to be speaking.
Okay, you can sit down then.
No, I'm not going now. But it's such an interesting topic, and it's such an interesting question. A protectionist trade instrument. So it doesn't have to be the perfect protectionist trade instrument. And I think looking at the motion, it doesn't have to be only a protectionist trade instrument. It could also be something that serves other purposes, notably human rights. And it's certainly the case, in my view, that the primary motive of the GDPR is not about ring-fencing European industry. And even when we look at the advocacy regime, I think it's pretty clear that the primary purpose is not to ring-fence particularly preferred trade partners. I will probably vote against this motion, but nevertheless, I think it's very difficult to argue that it doesn't have a discriminatory effect. Because when you look at the advocacy regime and just how politicized it is in terms of who gets in the door and who stays in the door, I think it's simplistic to say anyone can apply, it's equal criteria. The European Commission was meant to be reviewing the countries which have been given advocacy status. It's about 3.5 years out of date by which they were meant to be doing that. Meanwhile, there are countries which want advocacy and seem to be given no proper hearing. And when you look at that list, you can't help but feel that there are some political factors going on, including the countries which fail to pull off the list. Even with the US and the first US safe harbor regime,
So can we wrap up?
okay, the bespoke arrangement just for the US with an opt-in system was not offered to Australia and was not offered to many other business trade partners. So it seems to me that yes, the advocacy regime is operating in practice as a discrimination regime, and if that is enough, then it is protectionist trading.
Thank you. Eduardo,
Thank you very much.
you have to introduce yourself then.
I very respectfully, I'm Eduardo Ostran.
No, I know that, but they...
I just wanted to say I respectfully, very respectfully disagree, and strongly disagree with the opposer, in the sense that I think that the practical application of the GDPR falls very squarely into that definition of protectionism. And the reason why I say that is because, according to what I see on a daily basis, on a number of cases I've seen on a number of occasions throughout the years, when you look at the definition you were referring to and the two components of the rationale
and the discriminatory effect. First of all, at the moment, regulators all over Europe are applying the GDPR and the provisions of Chapter 5 of the GDPR dealing with international data transfer for the very purpose of protecting the European industry. This is leading and has led to calls for data localization in Europe. And when you listen to what the EDPB is saying these days about the conditions for international data transfers, it is very, very clear that there is the very purpose of those statements is to generate and to promote a European industry, tech industry, in order to compete with the US industry. So the rationale is certainly there, in practice. And you also mentioned the discriminatory effect. The discriminatory effect is very, very easy to spot, because which transfers to which particular jurisdiction are the concern of these European data protection authorities? Are the transfers to India a concern?
I have to stop you.
Are the transfers to China? Or the transfers to one particular jurisdiction that is a threat?
Thank you very much. Please.
Mr. Chair, from Latham. So the short answer is the adequacy regime is clearly discriminatory, and the EU is in breach of its national treatment obligations under GATT. And the simple reason for that is that if you are assessing the adequacy of transfers to the US, you need to consider national security law under the US in order to determine whether or not that personal data will be safe when transferred. But transfers from France to Germany are automatically permitted without any consideration of German national secrecy laws. That is discriminatory, without question, breach of national treatment obligations.
Thank you. Don't look behind you when I point.
Rebecca Swain at Barclays. I think one aspect that maybe hasn't been considered so far is, in practice, some elements of the GDPR, particularly around sort of treatment of staff and employee data, employee monitoring and that kind of thing, can actually have a negative impact on European businesses, or sort of European elements of businesses, and could potentially sort of discourage trade within the EU or sort of expansion within the EU. So that's, I guess, a counter and could actually negatively impact the EU versus other areas of the world, and perhaps was an unintended consequence, particularly where businesses are sort of looking at sort of multi-jurisdictional projects and potentially sort of investing in certain European countries. One aspect will be whether or not they can do the things they want to do in certain jurisdictions, and certainly in certain European jurisdictions that may well be prohibitive in terms of investing and sort of increasing headcount in certain jurisdictions potentially.
Thank you very much. I'm looking for other interventions, please. Please.
Jane Hunt, Tatiana. Is it discriminatory when, in the latest Meta case, could it not have been designed so that the data that Meta was processing could have actually been done within the EU? We've heard lots, and there's been lots of technology advances in pets and other matters. So where you have a decentralized service rather than working on centralized service. And is that discriminatory when those same laws would apply to an EU tech provider, even though there isn't one? So I think I personally am with the opposition.
Thank you very much. Looking for any further interventions? Third, last chance to ever say anything. You can have one further intervention. You've had 1 minute, though.
Okay, well, I had a minute left from when I was speaking earlier.
Yeah, all right.
So if GDPR were a protectionist measure, then you would expect the European Commission to be driving forward these protectionist measures. But what you in fact see is the Court of Justice driving them forward based on fundamental rights. So if you look at the source of, for example, the majority of restrictions of transfers to third countries, they arise from the Court of Justice under Fundamental Rights, not from the Commission and its role as trade body for the EU.
Thank you. Something to be able to tell your grandchildren? You spoke in the Cambridge Debating Union? Last chance? If not, then I will hand back to Ulrich. You have 5 minutes to, well, you have to wait until I've sorted out my timer first, and then you'll have 5 minutes to sum up. Starting now.
Thank you. The House believes that the EU GDPR is in practice a protective trade instrument. That's the motion. And one of the ways to win a debate here in the House is for the opposition to reinterpret the motion. So to apply an interpretation that makes it less persuasive. There is no question whether there is intent or not. I don't believe the European Union, the European Parliament, or the Court of Justice intend to protect European companies. What is happening here is basically unintended and has maybe other intention. One of the intentions is obviously to protect privacy. The other one is, interestingly, and that the urge of the European Union to spread the GDPR around the world. So if you do GDPR-like law, yeah, you get a benefit in trade because you can then get an adequacy decision and then you can trade better with us. However, that reasoning that you want to export your laws around the world, that you want to dictate to other countries how they should do this, would not be acceptable under WTO rules. Yeah? So that intention wouldn't allow you to build up these barriers to make it painful not to take over your laws. Then there was the argument that Facebook could, for example, provide could have a data center in the European Union. But how do you communicate then with your American friends? Because if their data would be processed by this data center in the European Union, according to the thinking of the European Commission, then they would all covered by the GDPR. And what would that be for? That would also not be necessary. The trade barrier there is that you can't, from your home, provide these services to the European Union. And that's something the WTO wants to stop. There is of course, there needs to be a flexibility for countries to have data protection laws, and of course, they need to be able to protect to some degree. The WTO, the GATS agreement, specifically, as noted, says that privacy law would be is under a derogation, so you could have privacy laws to protect. But the fact that GATS has it as a derogation proves my point that it is a protective trade barrier because it wouldn't need a derogation if it wouldn't be one, right? So GATS, the fact that there is a derogation doesn't prove that my motion is wrong, it proves that it is very, very true. And therefore, I refer to that as evidence for the fact that my motion should be supported. If anybody wants to know more about this, there's actually a doctor's thesis from Tobias Neef from Zurich. He has written over 400 pages on this issue. And I disagree with almost everything he says, but he recognizes that the adequacy decisions discriminate between different countries. And if anything tells you that my motion is right, then that. So please support me, and thank you very much.
Orla, the floor is yours.
So returning to our motion, that the GDPR is a protectionist trade instrument. As I mentioned, we propose that protectionism has its two components, the rationale and the discriminatory effect. So from the comments and the questions that have been taken from the floor and from our colleagues, we haven't heard anything to contradict the idea that neither of these conditions are met. So first, if we go to rationale, we had Mr. Oosteron say that DPAs or data protection authorities are applying the GDPR with the very purpose of protecting EU industry. This was an unsupported claim. We were given no examples, we were provided with no statements. Where is this protectionist intent from DPAs coming? What we know is that DPAs take their responsibility. We could debate whether some more than others of protecting privacy very seriously, but to imply an economic motivation to them is I think, wanting in support. Then our opponent said that the definitions of protectionism do not require intent. They do require an economic rationale. So again, going back to the definitions, it's the actions of a country or a region to help its country's trade. The GDPR was not designed to help its trade. We've heard from the opponent that there are no EU tech companies. This has been a long-standing issue. We've had this regime on data transfer since 1995. If the aim was to protect or to promote EU trade or EU industry, then surely after 20 plus years when the GDPR was being adopted, we would have changed tack because we might say our protectionist measures were not being particularly successful in practice. So I don't think we can impute that economic rationale to the EU or to the GDPR. Then on the question of discrimination, here we have some trickier issues. So on the question of adequacy, we might say, although again, Professor Erdos didn't provide any evidence that some countries had been banging on the door for adequacy and not given that opportunity. This begs the question, why have we seen since 1995, not a single GATS complaint about the EU's data adequacy framework being protectionist, or any kind of formal challenge to this. We might say that the Commission, and as Mr. Church said, that the Commission isn't, pursuing or is pursuing kind of a slightly different policy to the court, because adequacy isn't just what the Commission does, it's an entire institutional framework involving the EDPB, the Commission, the courts, and here again we have nothing to suggest that if, for example, the Israeli adequacy decision was challenged before the court, that the court would A-OK Israel while invalidating the US safe harbor. So the evidence of discrimination is simply lacking. On the issue of national security, which was rightly raised, so the EU obviously has no competence to assess the national security of member states. But what it does have in its back pocket is the idea that each and every EU member state is a signatory of the European Convention on Human Rights. And this is why, at the moment when the UK stepped out of the EU and therefore needed an adequacy decision, the Commission emphasised in the adequacy decision that the UK remained adequate as long as it remained a signatory of the European Convention of Human Rights, because we can be assured that while a signatory of the European Convention on Human Rights, it will maintain national security standards. So this doesn't, again, make this discriminatory. This simply says that within EU member states, you have a concept of mutual trust, that each and every one of them will adhere to the standards of the ECHR, where we do have criteria for national security.
1 minute.
And so, again, we're lacking evidence of this discriminatory effect. And maybe just to really emphasize this, we look at a case from the Court of Justice like Digital Rights Ireland. What did the court do? It attacks, in some ways, the EU legislature, not the legislature of a non-EU state, but the EU legislature, and invalidates its legislation for failure to comply with the EU's strict human rights standards. And in that it says that data localization is a component of the protection of those human rights standards. So here, rather than discriminatory, what we see is that we have entirely consistent case law from the court on the idea of data localization and movements of data. And therefore, that's why we propose that, while well-intentioned, our colleagues are mistaken in suggesting that this is a protectionist motion.
Thank you very much. So Thank you, everybody, for your participation. I'd like, first of all, to ask you to show your appreciation to our 2 proposers and 2 opposers. And of course, the best bit comes now. Don't go to the eyes or the nose doors. I've told you that already. Okay? But the motion is, this House believes that the EU GDPR is, in practice, a protectionist trade instrument. All those in favour, please raise your hand. Oh dear, I'm now going to have to count.
I think it's pretty clear we don't.
More shoddy evidence.
Anybody counting with me? 1, 2, 3. Thank you. All those against? I've passed the number of in favour, so therefore the motion has not been passed. Thank you very much indeed.